that that was the proverbial straw that caused her demise. But there is the bigger damages question for you guys to wrestle with, and that is your mom had a number of health issues, and the most troubling of those for me is she had a condition called cachexia, which is basically a wasting away, which is often a condition seen in people at end of life where they don't want to eat anymore. They start to lose weight. They become frail. And that was a condition that appeared to pre-exist her hospitalization, where she was not getting good nutritional support. And that is usually a hallmark of very late end stage passing. It's recorded that for most of her stay, she didn't want to eat anything, which to me is also troubling. And so the question will be, if a lawsuit is made, how much longer your mom was going to survive if she hadn't fallen off the table and if she had gotten a better quality of care in the hospital leading up to the fall off the table. And, you know, I've had cases where I've defended cases where a similar situation where I argued the patient wasn't going to survive hospitalization, and obviously the arguments were it may not matter that mom was going to live 6 months, but you took away the opportunity to say goodbye. You took that away. And in that case, even with the arguments, and we had liability, even with the arguments, you know, we paid $100,000 to the family. And that is not really a whole lot of money. It seems like a lot, but it's not. And so first of all, I'm concluding there's negligence, but I think that for your peace of mind, I guess what I would recommend is you've got to get an expert, an intensivist or a critical care doctor. They have specialties in critical care and infectious disease who can look at the records and give us a better approximation of how much longer your mother was going to survive. And if that opinion is probably 3 months, could be 6 months, or if that opinion is no, she's not ever going to leave the hospital, you can weigh your options at that point. I'm not skilled enough to look at these records to say what your mom's survivability would have been, but for the negligence. Mm-hmm. I can tell you what the arguments are going to be, and again, their argument's going to be she was in critical condition, which is why they wanted to put in that Swan-Ganz catheter. She was already in fairly bad shape, okay? But you're not without arguments. Certainly the argument being if she hadn't fallen off the table, we were already planning to come. You took away the opportunity to say goodbye. We will never know how much longer she was going to survive but for this. And that may have some value. But so I want to talk about value. I can't tell you what I think the value of your mom's case is, but I would say, there are under the medical malpractice laws, what we call the MICRA laws currently, and this is only up through December 31st, the current limit on recovery of general damages, which is pain, suffering, loss, is $250,000 for the death of somebody. Effective January 1, the MICRA laws were finally changed, and that limit is going to go up to $500,000. I would say, knowing everything that I know in the records, you may, certainly with the fact that there's such overt evidence of negligence, you may be able to get UCSD to pony up $50,000, $100,000, something like that. But to get to that point, you would need to have an expert on board to express opinions on both negligence and life expectancy. And let's say, I'm just going to kind of give you, let's say, with all things being considered, UCSD offers up $100,000, and that's really probably, that ends up kind of what everybody thinks the case is worth. Court costs, expert costs, and attorney costs, the net that would be able to be divvied out to family members might only be $40,000 split 4 ways. And if this is about vindication more than money, great, I understand that. It will take some effort on every sibling's part to participate in the lawsuit. Every sibling would have to join as part of the case, and would have to respond to written discovery, questions, perhaps even deposition, things like that, before they would pay out money. So there's a bit of not only effort, but there's an emotional toll that's taken. I just want you to be aware of by participating in the lawsuit, and that the upside might only be a net of $40,000 to $50,000. It might be higher, it might be lower, and you have to weigh that. I think when I first looked at the records and saw the evidence of negligence, I was thinking, this is a really tragic, interesting case that I would like to take on. But the more I looked at all of the health issues of your mom, I saw lots of issues and problems with taking it on, and didn't see a significant upside in terms of recovery. I think you need to press UCSD to give you the complete set of the records. I think you need to have a intensivist, like a hospitalist, look at the records and tell you what they see in terms of the morbidities and survivability. And if they say, yeah, mom very well could have survived a lot longer, or if she couldn't survive longer, that the reason she didn't survive was less related to the fall off the gurney and more related to the quality of care that preceded that. So that's what I see. I want to, give you the pragmatic viewpoint on how this might shake out. Okay. And I'm open to any questions that you may have.
Yeah. Thank you.
No broken bones. No. There was, she had some skin breakdowns on her buttocks and on her heels, which is typically seen for someone who is bedbound for long periods of time, who hasn't been turned in bed, and they pre-existed her arrival to the hospital and probably came from the care home or I think the record suggested that she was living with one of the sons preceding the first hospitalization that she had, because there was an earlier hospitalization where she was treated for COVID. She kind of went home for a few days and then came back to UCSD Scripps. But there was skin breakdowns on the buttocks and on the heels. But that's all that I saw.
Well, I don't have any questions, but I thank you for taking your time to look at this and discuss these medical records with us. And I think as a group, we need to, decide what we want to do. And I appreciate the honesty, as far as the likelihood, the costs and benefit of pursuing with the case. Thanks.
Okay. Just be aware, because she passed away on the 25th of February, that's your statute of limitations. You will have to have filed the case before February 25th of 2023.
Okay.
You can extend that for 90 days. And there's a way you can do it, but for all intents and purposes, the statute of limitations is February 25th, 2023, which gives you time. But again, if you file into next year, you can at least allege that your general damages, the potential general damages recovery is $500,000, not the $250,000 under the law that will sunset on the 31st of this month.
Okay. If you mentioned the court costs and attorney fees and expert fees being in the neighborhood of $60,000,
yeah,
is that something that you see these experts, attorneys, and courts being paid out of a judgment, or is that cash that we as a group would need to pony up on the front end?
Let's say you retain me. I already know the guy that I would want to engage to look at the records, an intensivist who I've used on several other cases to look at that. And the initial outlay to him would probably be about $5,000. But court costs, attorney's fees, and expert costs are all borne out of the recovery, whether it's by settlement or by judgment. And then if the case gets tried and is lost, and then the only exposure you folks would have would be the court costs and expert costs. You wouldn't owe me any attorney's fees because I would not have produced a result for you.
What do you project court costs to be?
Well, if we go to trial, which would be 2.5 years down the road, the court costs might be $20,000. There's filing fees, jury fees, deposition costs, things of that nature. They could be up to 20,000. I don't anticipate that they'd be any higher.
In your experience, I don't have any idea how this stuff works, but in your experience, is this something that would be likely to go to trial, or do you think that they would just pay out?
The evidence of negligence against them is so strong that, at least in my experience with the hospital clients, this is the kind of case where they would evaluate it and say, we don't want this case to go to trial, or they may look at the optics and the publicity that comes out of it and say, we don't want this to go to trial. I would say, at least from the standpoint of negligence, that it is unlikely to go to trial. But then again, let's say we make a claim and we hold out for $500,000. They would try a case. If we ask for the maximum recovery that is allowed by law, they would try the case. I would try the case if I'm representing the hospital, because there's no downside to trying the case at that point. If my exposure is the best settlement that they will take, then I'd try the case. And again, their arguments are all going to be on causation and damages and not on the negligence. They're going to roll over on negligence.
Okay. Well, I'm just speaking for myself here, but I don't have $25,000 that I can, part with for any amount of time. I don't know the financial position of anybody else. And
Alex, if I would not, no lawyer would ask the family to pony up or advance the cost. The lawyer bears the risk for the duration of the trial in terms of all those costs. So in other words, you don't have to pay them out up front. The lawyer or the law firm fronts those costs.
Okay. And is there an interest associated with those costs?
No.
Okay. And when you say that the costs are handled up front or fronted, for lack of a better term, by the law firm, does that include the retainer fee or the expert fee?
Yes, it does. All those costs are fronted by the lawyer.
and you're predicting that you mentioned, say that there's $100,000 settlement. Is that scalable? If it's a $500,000 settlement, would the attorney's court and expert fees still be 60%?
No, and that's see that's a darn good question and kind of requires a long answer. I'm sorry, Alex. So the attorney's fees in med mal cases are set by statute, and there's a staggered percentage. So for the first $100,000 of any settlement, the lawyer's fee is $40,000, and then from $100,000 to 250,000, no, to 500,000, the fee is 33 1/3, and then any recovery above 500,000, the fee on that is 15%.
When you said 33 1/3, that was 33 1/3%
of the recovery.
Okay,
the total recovery.
Gotcha.
Yeah.
Okay.
So
and then under 100,000 and under is $40,000, not 40%.
Same thing, correct.
Okay, but I mean, is it 40% if they were to pay out 50,000? Do we owe $40,000 or 40% of 50? It's 20,000.
It's 40%, 20,000.
Okay, so it's all percentages. Okay, cool. Correct. That makes sense. That's all the questions I have. Sorry.
Okay. Sorry. That's absolutely correct.
One more question on that note. Assuming there is no recovery, and you've fronted the money for the court fees and the expert cost, how does that then come back to? Do we receive a bill as the four of us, or does one of the children receive the bill? I know Zach doesn't give a shit about his credit.
Yeah. It would go to all, and it would go to all.
Okay.
You know, that's a valid concern. It just, despite everything I've said, I am not, and again, this is based on my experience representing hospital groups. I don't believe it would get to a point where we're walking away with zero, or we go to trial and we get zero. There's going to be something to it. Mm-hmm. Even if Frances was going to die 2 days later or 3 days later, the argument that it hastened her death and took away the opportunity to say goodbye is still compelling and still has a value to it.
Well, what's frustrating to me is that morning, I guess it was before noon. So that morning, I was on my way to the hospital. I didn't find out she was in the hospital until, a few days before that. I was required to go get a COVID test and present a negative result in order to see her. And I had parked my car, walked into the waiting room and presented my document. They said, "Oh, she's in for a procedure that's going to be several hours." I was like, "Okay." I had spoke to a doctor earlier that day, and he said, "Yeah, she's able to be seen. She's coherent, whatever. Come down and see her." And then I left with the intention of coming back the next day to see her after this procedure. And I spoke to the doctor again, and his words were, "There's no." I said, "Do I need to come down there right now?" When I got home from the hospital at this point, I spoke to the doctor, and he asked about doing the procedure in ICU and not where they were initially going to do it because he had mentioned a fall. And I said, "Okay, do I need to come down there?" Because I was on my way to work. He's like, "No, it's you'll be able to see her tomorrow." And I said, "Okay." So I went to work, and then he calls me at work and says, "If there's any family in town, you might want to come see her now." And then that's when Zach and I met at the hospital, and there was no, we couldn't even speak to her. She was unresponsive.
Yeah.
And that was what sucked, because even if that was going to be the last day I saw her, had I got to see her in the morning when I tried to see her, at least I would have been able to say hello and like have some dialogue with her.
I get that. And yeah, according to the record, she was responsive that morning before she had the procedure.
Yeah. So I'm sorry. That's kind of off the topic, but
no, but that's difficult. I know it's just something to process through.
Well, and then Brian and Elizabeth and Isa didn't get to, say goodbye at all.
I know.
That was.
And I had a flight scheduled for that Tuesday.
Yeah, people were on their way out. Yeah.
Mm-hmm. Yeah. Yeah. And this is the illumination that you guys can provide that I'm not seeing in the medical records, because it almost looks like there's a circling of the wagons after she fell, according to the record, and then they sort of played up the severity of her other overall conditions as the reason why to make her comfort care. But with your input and illumination of those things, it does seem to sound strongly like the fall was a big precipitator to her immediate decline. Mm-hmm.
Well, and after the fall, when the doctor called me to get my permission to perform this stent procedure in a different wing in ICU, I asked him, "Do I need to come down there?" And he said, "No, you come down tomorrow. Everything will be fine." And then 2 hours later, he said, "Get down here."
They were going to start it, and she fell. And that's another oddity, is the surgeon who was going to do the procedure, he has his dictated procedure note, which says that the procedure went well and went uneventfully. And that's completely wrong. But these doctors use templates. Their op notes are already partly dictated. They just work from a template, and then they sort of fill in the blanks. And so he signs off on this op note saying the procedure went forward and was uneventfully, and the patient was awake and responsive. That's all bullshit. That never happened.
Okay.
Okay. Well, you guys got some things to talk about amongst yourselves.
Yeah.
I'm not telling you to fold up your tent and say, okay, we've gotten closure